So here's where we are. Thanks to an appeal by Donald Trump, the Supreme Court will be hearing this attempted ballot ban case tomorrow. Trump's team says they'll also appeal the big loss yesterday, which puts him back on track to be tried for those election plots, which I mentioned earlier in the program. Trump must formally file that appeal by this Monday, which is widely expected. Then SCOTUS can deny it, which would leave the trial on track, or take it and slow things down. Now, depending on what they do, a certain type of delay could actually end up biasing this whole case. If the justices take their time and guarantee a trial could not occur before November as Politico writes, well, that has huge repercussions. On the one hand, if Biden wins re-election, then the voters made up their mind without the knowledge of what happened in the trial, and the later trial would presumably continue. But if Trump were to win the election under our system, under our rules, the DOJ, under his control, could then dismiss a DOJ case. That means that the Supreme Court, if it acted to do this type of delay, that would function as kind of an assist to a dismissal. That would mean that no trial would ever occur, and the Supreme Court would get away with or have the result of barring the trial without having to say that they did so. Now, the justices are in D.C. They're well aware of the political calendar and all kinds of other intrigue, while the justices also typically insist that they are completely independent from never making laws based on their personal views and political preferences to avoiding the court's politicization.
A judge must be independent and must interpret the law, not make the law.
I do believe that judges must apply the law and not make the law.
The courts should not be politicized.
The question is not, do you like this party or do you like that party? The question is what the law requires.
That the judge's job is to follow the words that are in the law, not replace them with those that aren't.
That's what they say. It's kind of a pastime. But the court did have a pretty obvious partisan tilt in the one big presidential election case that it's resolved, Bush v. Gore in 2000. And some of the people in robes today insisting they would never, ever look at the law, the words in a law, through a partisan lens are the same people who did just that in the same exact 2000 case. They were well-placed elite partisan lawyers at the time for Bush. John Roberts, Amy Coney Barrett, and the very controversial Brett Kavanaugh. Now, this is known. This topic came up in their confirmation hearings. One of the more recent Trump appointees, Barrett, was reportedly dispatched to Florida to help Bush's legal team deal with absentee ballots. Washington Post has written that up, but she claims she barely remembered it.
I did work on Bush v. Gore. I did work on behalf of the Republican side. To be totally honest, I can't remember exactly what piece of the case it was.
That's interesting. Can't remember that. Now, another controversial conservative stalwart, Brett Kavanaugh, was a partisan lawyer on the Bush team. We checked and found him discussing the same case in 2000, right after the Supreme Court heard the oral arguments. He was dealing with the recount litigation. And I think we have, do we still have that sound to play? Not even then. I want you to, yeah, we do. My bad. I was going to show you this. I want you to notice how even then, he knew the game. He was doing everything in his power to be a partisan advocate for Bush, to get a partisan result where the court would do things that made Bush winner and president. But he still knew. You don't admit that. You talk about how, well, the court's just going to deal with the words and the law and not try to think about who it's going to benefit.
I think what we're seeing is more of a divide over how to interpret the Constitution than really political differences. I don't think the justices care that it's Bush versus Gore or if it were Gore versus Bush. What they care about is how to interpret the Constitution. What are the enduring values that are going to stand a generation from now?
Remember, the person you're listening to did the opposite thing in courts and in his litigation advocacy. He's trying to get Bush to win no matter what, and they did prevail. But he's saying, hey, you know, this court, you know, they don't look at that. Now, there's John Roberts, who, to be very clear, has done many things to try to protect the court's independence since he joined. But on the other, you have to remember, he has watched these Republican extremism issues really dog the court in recent years, as well as the ethics scandals that have only occurred thus far on the Republican side. If Democrats have a donor ethics scandal, Democratic appointees on the court will report it and scrutinize it, but it's only been on the right. This election year will be Roberts' largest test yet, as best we can tell. And during his hearing, he argued he shouldn't even discuss his past work or the result in Bush v. Gore.
I do think that the issue about the propriety of the Supreme Court review and matters of disputed electoral contests, it is a matter that could come up again. Obviously.
You notice how even our skilled team of researchers who cut the sound bites couldn't get a clear sound bite out of the guy because he wasn't trying to be clear. He was trying to dodge and weave, and what he was saying there was, well, that issue could come up again, so he didn't have to speak on it. And to be fair, it is true that if there are matters that could come before the court in the future, they're not supposed to say what they would do on that before they rule on it in the confirmation hearings. Having said that, I think it's quite obvious that he, like the other judges, now justices I showed you, are very careful around this, because they don't want everyone to think of them as partisan Republicans in robes, and yet on the big cases, the question is that all they are? Now, Sandra Day O'Connor was known as a pretty pragmatic member of the court, and she once later mused about this controversial decision in Bush v. Gore. Maybe the court should have said, we're not going to take it, goodbye. Or if you're a real political junkie, you might know how John McLaughlin used to say, bye-bye. The point there is maybe the court is better off erring on the side of letting things play out and certainly not interfering. Now, in the Colorado case, they almost certainly have to rule on this, hear it tomorrow and rule, because they have to decide whether everyone's going to be on the ballot or not. But it's the opposite in the Jack Smith case. They can stay out of it, as O'Connor basically said might have been best, and let it play out. And there can be a decision, a verdict before the election, and they can let that play out. So these are tests. And does this court have enough credibility left to do the Republican partisan lever again? To do that on 2 cases in a row, when we might need them even more in November if there's a close outcome? Those are serious questions, and I do not have the answers for you tonight. I can just tell you they are about as serious as a constitutional heart attack.